Good evening, friends. Amongst us, we have SREENIDHI KR, who is the faculty in the CMR University School of Legal Studies. And those who have been connected with Beyond Law CLC are well aware that we have done a lot of sessions with the faculty of the CMR Legal Studies. Mr. SREENIDHI has also taken 3 sessions earlier with us. And today's topic is understanding the concept of constitutional identity. I'll straight away request Mr. SREENIDHI to take over the session since already we are running short of time.
Good evening to everyone. I'm very happy to be continuing another session here with Beyond Law CLC, which has been doing great work, bringing topics of very contemporary relevance again and again, with great speakers, and it's an honor to be a part of this endeavor. Coming to today's topic is a very special topic for myself because, I've been reading about it and researching about it for quite some time. And it is something that goes to the very root of, constitutional law, and it is something that is very important, and it is of extremely contemporary relevance also because the concept of identity of the Constitution, is something that has been in focus, although maybe most people don't, connect with it at a very literal level. But then it is something that has always been in focus because there has been a lot of talk as regards with the Constitution of India, especially in the last few years. There has been a lot of issues that have become to the fore. There's been a lot of, political rhetoric that has gone into discussing the Constitution on a very public forum in very recent times. And that's a very good thing because, awareness of the Constitution and awareness of, the nuances of our constitutional identity is something that is very important for all of us to know. And it is something that is very useful also in terms of understanding the various aspects of constitutional interpretation as such, because that helps us in understanding and appreciating our own constitution in the right way, as much as possible. Having said that, let's come to the topic. The topic is that of constitutional identity, and the concept of identity itself is a kind of a tricky concept because it has got a lot of philosophical overtones to it. As such, the concept of constitutional identity also, if you want to really go back and find out where it comes from ancient times itself. In fact, no other than Aristotle has spoken about the concept of constitutional identity because he said, if I remember correctly, he said one of the best ways of finding out, the identity of a republic is to find out what is there in its constitution. So the concept of a constitutional identity associated with the identity of the republic was something that was introduced at that point of time. However, we are looking at this concept in more of, a contemporary way. During contemporary times, the concept of constitutional identity, the modern concept of constitutional identity is something very new to us. In fact, it is something that is being discussed from the past maybe about 20 years, by many scholars, in different contexts. And a few of the very interesting people who have been writing about the concept of constitutional identity is a very interesting professor called Gary Jacobson. We have Michael Rosenfield, who have been discussing the concept of constitutional identity from a very long time. But then, it is something that is growing in relevance as far as constitutional law and constitutional theory is concerned, and therefore a lot of new research is coming to light, as we speak. And it is something that has come into a great deal of practical relevance as well, in terms of the way in which it is understood and implemented by the constitutional courts of many different countries, many different, constitutional republics. Coming to the meaning of constitutional identity, to understand the nature of the concept, I think we should be clear about one thing. There are two ways of looking at this concept. One, we can look at it as, from the perspective of identity as a constitution, or we can look at it from the perspective of understanding identity of a constitution. And there's a very big difference between the two. When we talk about identity as a constitution, we are talking about what are the various different features and issues that go into the making of a constitution. And that's a very fundamental concept, constitutionalism at its very core. We talk about how, all modern constitutional republics to be recognized as modern democratic constitutions must possess certain, uh, you know, uh, identifying characteristics which would identify them as modern constitutions. And this gives them their identity as a constitution. Otherwise, in today's politics, we see there are so many different nation states which have constitutions of their own. In fact, every country will make a constitution for itself, but that does not necessarily mean that that particular country or nation is a constitutional democracy. It only means that they purport to be adhering to a constitutional document. But the veracity of the document, the importance that is given to the document, is what signifies whether that particular constitution is an actual modern democratic constitution or not. For it to be so, it must fulfill certain very important basic requirements. The most fundamental of which being the fact that such constitutions must, uh, be made from the perspective of ensuring control over government. That is the basic objective of any constitution. And this is achieved through the various different tools that a constitution employs for this purpose. And these tools are, we know of these concepts like rule of law, the fundamental rights, the concept of federalism, the parliamentary democracy, the will of the people. All of these go into ensuring that a constitution keeps government in check from over exercising their power or making misuse of such power. So this is what we mean by identity as a constitution. But what we are talking about today is not about this. What we are talking about today is the concept of constitutional identity, which refers to the identity of a constitution. And what determines the identity of a constitution? What does this concept entail? There are various different ways in which this particular concept has been handled. You know, in uh, 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 in the brief history uh, of its development as a concept of constitutional law, there have been various different perspectives that constitutional scholars have come up with. Number one, you can look at it in a normative fashion. A normative fashion in the sense that there is a written constitution, and this written constitution adheres to certain important features of constitutionalism. And an examination of the various different features and how they operate within the confines of this particular constitution tells us what the identity of this particular constitution is. A second way of looking at the concept of constitutional identity is to look at it from the perspective of historical constitutionalism. This is something that has been, discussed a lot by Spanish scholars, European scholars, basically, who talk about historical constitutionalism. They are of the opinion that constitution of a nation is made on the basis of the way in which it evolves and develops over history. These are basically nations which have had a very rich political history, a very linear political history, where they have gone from phase to phase and stage to stage, and their constitutional democracies have evolved from being outright monarchies to being maybe parliamentary democracies or parliamentary or constitutional monarchies at this point of time. And these scholars from these nations believe that the only constitution, the only valid constitution is one that does not deviate from this history. They believe that making a constitution is tantamount to rejecting the old constitution, rejecting the heritage, tantamount to rejecting the identity of the constitution itself. So there is this bunch of scholars who look at the concept of constitutional identity from this perspective. Thirdly, there are some scholars who look at the concept of identity as something that is attached or pertinent to other relevant identities. When we talk about identity, identity is a very dynamic concept. Identity can mean many different things. Identity can refer to your national identity. This is something very common, and this is something that there are a bunch of people in all countries who are ardently believers in the fact that their national identity should not be let go of. So here, there is a tendency for some scholars to associate constitutional identity with national identity. On the other hand, there are some scholars who believe that cultural or religious concepts have an important bearing in terms of figuring out the constitutional identity of a particular system. Thirdly, ideological, and this is again another common form of understanding the constitutional identity, is to understand it from the perspective of the ideologies that have gone into making of this constitution. So these are the various ways in which we can understand the concept, various approaches that we can undertake to understand the concept of constitutional identity. But what about the concept itself? As a accumulation, as a comprehensive assimilation of all of these various perspectives, where do we come to? We have come to a situation where we have come to realize that primarily, the concept of constitutional identity implies the existence of primarily a common identity. And this common identity is founded upon the fundamental principles of constitutionalism itself. Now, we have come to understand that for a constitution to be a constitution, it must, be identified through certain important features. Number one, the limitation of governmental power. How do we achieve limitation of governmental power? There are many ways in which governmental power can be limited. As far as constitutionalism is concerned, that it identifies, certain horizontal controls and certain vertical controls. As far as horizontal controls are concerned, one of the most common ways of ensuring the existence of horizontal controls is to have separation of powers as a part of your constitution. Of course, if you look at the Constitution of the United States of America, which is probably one of the first written modern constitutions of the world, you can see how beautifully the concept, the doctrine of separation of powers was incorporated under the Constitution of the United States of America. Now, there are at the time in which America became independent and America wanted to make a constitution for itself, there was great influence that came in from the French, because the French were natural allies of the Americans at that point of time, because the Americans were fighting against the British, and they decided that the best way for them to ensure international recognition was to be able to declare independence. Otherwise, any other country helping the Americans would have been tantamount to interfering the internal affairs of the British Empire. So to avoid this, the Americans declared independence, and promptly the French, recognized them as a nation and came to their help. And they became natural allies in the American war against the British for independence. And America became independence. The French also went through their own revolution, and one of the most important contributions of this French Revolution to the history of constitutionalism is the importance they attached to the concepts of liberty and to the doctrine of separation of powers. And naturally, the influence rubbed on to the Americans. there were great scholars at that point of time in America, and they immediately recognized the importance of taking this, doctrine and importing it into their constitution. And lo behold, they had a beautiful way of ensuring limitation over the power of the federal government. They divided the government into three organs. There was a legislature, an executive, a judiciary, and they inserted into the constitution an intricate system of checks and balances through which each one of these organs would keep a control over the other, and thereby they achieved limitation over governmental power. There are other means as well. Similar methods are implemented under the Constitution of India as well. There are controls that are inserted into the constitutional provisions related to each of the individual organs. In fact, these are known as intra-organ controls. The organ controls, the parliament is a very holistic entity, which has got a lot of control that is embedded into the procedure of the parliament itself. The various complicated processes that the parliament engages in ensures that no one person will be able to usurp all the power for himself or herself. Then there are, inter-organ controls, the organs exercising control over each other. The concept of judicial review, with which the judiciary has been empowered. The concept of judicial independence, which has been a very important feature of our own constitution. These are the ways in which, we exercise horizontal control over governmental power. On the other hand, we also have under constitutional system a way of implementing what we call as vertical controls, and these vertical controls, are numerous. There can be many different forms of vertical control, but the most common form of vertical control, that I can talk about here is the concept of federalism. Federalism, as a concept, again, we go back to the Constitution of America, where one of the most important discussions that took place during the making of the Constitution of America was the very strict requirement by Americans, by all the different representatives of the various states in America, that uh, that the autonomy of the states should not be taken away. This was one thing that they were very particular about. Because of this, there was a very strict concept of federalism that got incorporated into the Constitution of America. In fact, the Constitution of America, if we talk about it, is strict necessary. What do we call a constitution like our constitution? The power of the states, are very clearly recognized by the federal government, and the constitution itself incorporates various different provisions which are related to the federal government. Over time, this particular federalism in America has eroded, no doubt. We all know about it. The Supreme Court of America, through various decisions, people like Justice Marshall have intervened and ensured that, the states are, a little under the control of the federal government. However, federalism persists. And what federalism does is federalism ensures that there is a distinct control that is exercised by the state over the federal government and by the federation over the state government. How this is achieved, if you observe our own constitution, is also a fine example of how a federal system can work. The distribution of powers that has been made under the 7th schedule, where certain things can only be acted upon under the domain of the center, certain things can only be acted upon by the state. This kind of ensures that nobody controls everything, and thereby this becomes a vertical control. Another very important form of vertical control is the, fundamental rights. Two more things I want to talk about when we talk about limitation of governmental power: fundamental rights and the applicability of the concept of rule of law. Rule of law as a concept is extremely essential to constitutionalism, is extremely essential to all concepts related to constitutionalism, because rule of law is what uh, is what acts as the fundamental construct for constitutionalism. Rule of law ensures that there is no one above the law, and as such, uh, you know, uh, the supremacy of the constitution, the fact that no organ, like the parliament instance, if it is allowed to amend the constitution however it wants to, then it will become a body that is above the constitution, and as such, we will not be able to, restrict the power of the parliament. So, in order to restrict the power of the government, you have to have the rule of law, which is embodied in the constitution, and fundamental rights, which is the people themselves can become the a tool against the governmental power. So they can act as a limitation on the governmental power, where the government transgresses into the various rights of the people can act against such things. In India, like we know, we can approach either the High Court or the Supreme Court and ensure that these fundamental rights are respected. So these are some of the aspects of a constitution that allow us to understand a common identity of constitutions. All constitutions have, these things. This kind of, forms a part of their common identity. But then, if we are looking at a common identity, how are we going to be able to identify individual constitutions? That becomes a very important question. Now, if all of them are similar, how do we know what is the identity of the Indian Constitution? How do we know what is the identity of the American Constitution? So, for us to understand constitutional identity completely, we must understand not just the concept of this common identity, but also how, in a particular way, the constitutional identity is, for lack of a better word, identified or figured out. Now, what to look for when we are looking for constitutional identity? Number one, goes without saying, there must be a constitution. It must be a constitutional democracy. And two things we look at when we are trying to understand the various different aspects of constitutional identity. Number one is the content of a constitution. Of course, we just said, there are various different things which form the content of a constitution, like, these concepts related to limitation, like whether it is the doctrine of separation of powers, the rule of law, or fundamental rights. These form the content of the constitution. And these are, we already discussed, these are part of the common identity. What are we going to get by looking at them in a little bit of detail? By looking at them in a little bit of detail, we are able to identify the nuance, the way in which these various different aspects of constitutionalism have made their way into the constitution, into a particular constitution. For instance, if you are looking at the Constitution of India, just now we were discussing federalism. Federalism, works differently under different systems, as most of you will know. So having federalism in itself, yeah, it might give a kind of common identity to the Constitution of India, but then truly understanding the way in which federalism works in India would tell us that there is a nuance to it. There is a very important difference. There is a very singular way in which federalism has been incorporated under the Constitution of India. And this singularity, this uniqueness of the way in which we have incorporated federalism adds to the distinctiveness of the constitutional identity, which is why I say content of the constitution is very important. It's not enough to only look at the features of a particular constitution. The features tell us that it is a constitution, but it is also important for us to understand the nuance, and we can only understand it through the interpretation of the content of a constitution. Another very important thing that we need to look for is context. Context is a very important thing, but context is, again, a very tricky word, because it has different connotations. Not necessarily different meanings of the word itself, but then it indicates at various different phenomena. Context, when we say we need to look at the constitution or the contents of the constitution in reference to context, what provides the context becomes a very important question. Context in this regard becomes, various different things. For instance, I would just like to narrate a small, incident that happened at the time of making of the Constitution of India, when the Constitution of India was newly made. At that point of time, there were a lot of criticisms that were levied against the Constitution of India by many Western scholars. And some of them at this point of time may seem outlandish, but at that point of time, much scholarly writing went into debating whether the Constitution of India, the new Constitution of India, would work or not. There's a very interesting article that was written by Professor P.K. Tripathi, one of the very interesting personalities of constitutional interpretation in India. And he was writing for the ILI journal, where he discusses these particular criticisms that were made against the Constitution of India. And he goes on to, analyze them in detail, and he talks about, a few of these criticisms. He says, Western scholars have said there are certain things that are, detrimental. There are certain things that are going to ensure that democracy and rule of law and individual liberty will not work in India. And what are these, concepts? He says, number one, Western scholars say that India is a land of a Hindu majority, and being in a land of Hindu majority, almost all the people of India tend to believe in the concept of karma, which teaches the people that they should accept what is due to them, which means that in spite of living in a democracy, they will not stand up for their rights. But P.K. Tripathi goes on to disprove most of these concepts. Another thing, Western scholars had one of the pet peeves, one of the most important things that they spoke of was poverty. The third thing was illiteracy. And these scholars argued that poverty and illiteracy are going to detract people from political issues. Poverty is going to ensure that the people are only going to be bothered about earning their livelihood. They're not going to be bothered about governance. They're not going to be bothered about, what the government is doing. These are the things that were levied against. Illiteracy, again, was a very, very important drawback that India suffered at that point of time. However, writing in the 1960s, like I said, this person went on to defend against most of these criticisms that were levied against the Constitution. He said, just because we lack a tradition of democracy in our country does not mean we lack an understanding of democracy. He goes on to say that, if the Indian people were to lack an understanding of the concepts of democracy and rule of law and individual liberty, they would not have stood up for themselves and fought for freedom. The very fact that there was a movement against that existing tyrannical government itself goes on to prove that the people are ready to receive the power and ensure that the power is utilized in the right way. Of course, history by this time has gone on to prove, that these doubts that were raised against the Constitution of India were unfounded. But then, like I said, at that point of time, this was the context that many of the scholars were looking at. Like I said, we need to look at the context, But having said that, these particular issues that were taken as a reference to context were probably wrong at that point of time. What would be the right context? Various different things. The diversity of culture may be a very important concept. If you look at the Constitution of India, from the very outset, has given a lot of importance to the rights of the minority. It has given a lot of importance to the rights of the marginalized. It has given a lot of importance to the rights of the underprivileged. There are specific provisions in our Constitution which deal with these issues. And these provisions have made their way into the constitution, and they have been extremely effective in ensuring the management of the rights of such people, because of the fact, that in India there exists, a very beautiful form of diversity. It is a kind of diversity that has that is very unique to India. It is a diversity that not only encompasses the concept of race, but it also goes on, uh, you know, uh, uh, and draws from concepts like language, religion, culture, many different. There are different varieties, of people who occupy this, country, and this diversity becomes a very important context to understanding the various different provisions under the constitution. But only this. There are many other things. Our historical past becomes a concept. The influence of our modern political thinkers, the modern Indian political thinkers, people like Mahatma Gandhi, people like Jawaharlal Nehru, people like Dr. Babasaheb Ambedkar, people like Jayaprakash Narayan, all people like even Rajaram Mohan Roy for that matter. These are the modern Indian political thinkers. And these modern Indian political thinkers, although many of them were Western educated, if you take people like Gandhi and Ambedkar, and Nehru especially, they were Western educated, but then there was a very unique Indianness to their political thoughts. And this led to the development of a very unique, you know, uh, uh, political thought process. So, for instance, if you take Gandhiji, it is easy if we take Gandhiji because Gandhiji preached a very distinctive political thought. He speaks about concepts like Sarvodaya. He speaks about concept of ahimsa, and he speaks about various different concepts of of politics, which are very unique to himself. And it is an amalgamation of the Western political philosophy, what we learned outside, and the unique requirements of an Indian society and community, which Gandhi was able to understand through his travels, through mixing with the people of the country. He was able to figure out what India is all about. And he infused that into his political philosophy. And that becomes a very important thing to understand the context in which the Constitution of India was made and the context in which the Constitution of India needs to be understood. Also, there are several other things, which has been, at times identified by our judges of the Supreme Court as well. If you read many different judgments, some judgments there have been references to ancient Indian texts. In some judgments, there have been references to ancient Indian histories. In some judgments, there have been references to very uniquely Indian literature. You know, and these have proved to be a great source of inspiration for these judges to incorporate the values that have been embedded in us through thousands of years of history and import them into our understanding of the constitutional text. So, our understanding probably of justice is not without an understanding of the ancient concept of dharma, the concept of dharma, which was different at different times in history. The most ancient Vedic concepts of dharma are distinctly different from the concept of dharma as outlined in the religious texts of the Ramayana and the Mahabharata, which are very much a source of inspiration for the people of India. So, our understanding of uh, the concepts, the values that are enshrined in the Constitution are derived from our fundamental understanding of these very Indian concepts. So these become the context. So and we cannot ignore the context. Our language, our religion, our culture, our diversity, our ethnicity, all of these things become a context in terms of understanding the various different provisions of the Constitution of India. And if you look at the way in which these concepts develop, the provisions, the interpretation of the provisions develop in our Constitution, if you look at the brief history of our Constitution from 1950, we have had about 75 years of this Constitution, and there is a sea change in the way in which we interpret it. And this interpretation owes to various different ways in which we have understood this context. We must understand, number one, that the concept of constitutional identity, whether relevant from the perspective of content or context, imbibes and evolves through experience. So these 75 years of experience of having understood the various concepts that have been enshrined in our constitution and the way in which they operate in an Indian setting, is an experience that we have derived over time. If you look at the brief histories of the various different concepts of our constitution, let's take something as simple as maybe Article 21. Originally, the Supreme Court of India refused to interpret Article 21 the way in which we understand it today. In the case of A.K. Gopalan versus State of Madras, there was a very ardent argument that was made to look at the provision from the perspective of the purpose that it would have served for the public, for the people. So we argued for a purposive approach to constitutional interpretation to be undertaken by the Supreme Court. The Supreme Court flatly refused. Of course, there were many reasons for this. Now, if you want to look at it from the perspective of understanding the context was our judges of the Supreme Court at that point of time were judges who had been judges earlier in the high courts, under the British Indian government. And these judges were trained, on on a beautiful common law way of understanding interpretation. And if you look at it from an English perspective, they don't differentiate between constitutional interpretation, statutory interpretation. For them, the primary rule is the literal rule. For them, the primary way of understanding the law is to understand it with reference to the black letter of the law. It is called the black letter of the law. And the Supreme Court, naturally, also the fact that the Supreme Court did not want to meddle with this new constitution, also the fact that the Supreme Court did not want to do too much right away, also the fact that we were very skeptical about various things because we were just coming out of long tyrannical British rule. All of these went into, the Supreme Court's refusal to engage in purposive interpretation. They said, no, we are going to engage in a literal interpretation, and literal interpretation tells us this is what we have to do. But over time, not necessarily we go from A.K. Gopalan to Maneka Gandhi. Over time, we can see, how, the Supreme Court slowly relented in this approach in cases like Karak Singh, in cases like, the bank nationalization case, R.C. Cooper's case, over time, the approach changed. And in Maneka Gandhi, the concept got reversed. And we decided to look at Article 21 in new light. And that is how, the context materializes, through the provisions of the Constitution, through experience. And it is through experience that this identity devolves itself. And secondly, another thing we have to look at is that the process of identifying or the process of recognizing the constitutional identity is a dialogical one. It's a dialogical process. What is a dialogical process? Dialogical process is one that develops through dialogue, through constant interpretation. And our, Supreme Court has written, the judges of our Supreme Court over the past 75 years have written beautiful judgments that have run into hundreds, sometimes even thousands of pages. And these judgments have gone on to impress upon us not only what they feel is the right way of interpreting the constitutional provisions, but also what exactly went into arriving at that particular interpretation. So they record the reasons for it, and they have been, very vocal about it. And this dialogue that has existed, as a record, and this is what, most of us as lawyers, we study these judgments and we try to learn the law from these judgments. And that is how the law develops. It's a dialogical way of developing the law that we have engaged in, that our judges of the Supreme Court have engaged in, which has led to the Constitution of India going from, you know, the way it began to the way in which it is perceived now. So the identity develops through this dialogue, through this, it is revealed through these judgments, through these ideas that are, and lastly, there is one very important thing that contributes to the identity. It is not just, the experience. It is not just the dialogue. It is not just the context that, helps us understand, or that contributes to formulation of this identity. A very important thing that, contributes to the formation of this particular identity is the determination of society to transcend its past. Society is determined. At the time India made its constitution, we were ready to refuse what existed at that point of time. And we were determined to make good the new constitution and develop into a better. And it is true with, this is true with all societies. Whether it is the Constitution of the United States of America, which has been interpreted in that way. In fact, if you look at the Constitution of America, it has remained unchanged from the past 250 years almost. Except for maybe a few amendments that have been added onto it, 25, 26 or 27 amendments, I think, it has acquired very few amendments compared to Constitution of India. It is nothing. 27 amendments. The major amendments that came about at the time the Constitution was made itself, because originally the Constitution did not have a Bill of Rights. There were no fundamental rights. So the first 10 amendments, they had to add the fundamental rights, and they were made immediately. So if you look at it, if you discount them, there have been only about 15, 16 amendments that have come about subsequently to the Constitution of America, and it has remained unchanged from 250 years. And imagine the kind of interpretation that it has picked up along the way, the kind of context that we look at it from at this point of time, but also look at it from the perspective of the determination of the people of America, not just at the time of making their constitution, but also subsequently in the 1800s when America went through one of the biggest wars. They went through a civil war. Some of the states who were not happy with the policy of the federal government, they opposed these policies related to, slavery, the abolition of slavery. They did not want it to be abolished. It was a very commercial, reason for them not to do that. But then they said, regardless of what you are doing, our problem is with the fact that who are you to do it? This is a federal nation. And by making a federal law mandatorily applicable to the states, the federal government is usurping the power of the state. So these four states, they formed a confederacy. They decided to secede themselves from the union, and the union had to wage a war to bring them back into the fold. And this war almost broke, this federal constitution that existed at that point of time. Ultimately, the North won. Abraham Lincoln had a very cool head on his shoulders and the great president of America, in short. But the people, even in spite of having had such differences amongst themselves, the people were able to transcend this past. They were determined enough to put this behind them and go on to become a great nation, which is why they were able to work with the same constitution and ensure that it became a stronger force to reckon with subsequent to the Civil War, much more than it was before. So also the Constitution of India, in fact, if you look at it, there were so many different provisions of the Constitution of India which were very different, before the 1970s. Then we went through a period of emergency where, there was a supreme threat that the Constitution faced. And this threat that the Constitution faced from inside, many people believed that India would not survive. The Indian Constitution would not survive the lifting of the emergency. But subsequently, the emergency was lifted. And then the people were determined to move forward. A new government came into power. They made the necessary amendments. And just like that, we were able to rally behind our Constitution and ensure, that our Constitution went on to acquire a very different, understanding than what it was at that point of time. So this determination of the people to move on and transcend the past, everything that has happened in the past, they want to move on and they want, this contributes to the formation of the identity. And it's a very beautiful thing, because this particular thing is a representation of the will of the people. And it is the will of the people at the end of the day that the constitution itself represents. Right? So these are some of the things that go into making the identity of the constitution. But why do we do it? We do it because we want to, renunciate our pre-constitutional self. We want to ensure that what existed prior to the making of this constitution, is done away with. We are formulating a new identity and stick to it. We will ensure that, we exercise self-constraint and self-restraint to deal with the potential harms that are coming our way. We want to, and most importantly, the concept of constitutional identity acquires, great significance when we talk about it from the perspective of constitutional change. And this is the one concept that has given rise to a renewed interest in the concept of constitutional identity across, all countries. Many scholars today are talking about the concept of constitutional identity from the perspective of constitutional change. What do we mean by constitutional change? We are talking about amendments. How constitutions are amended. And an amendment can take away, make or break the identity of the constitution. And this is something that has been debated much by many different scholars. In fact, the whole concept is dealt with under a concept called unconstitutional constitutional amendments. What makes a constitutional amendment unconstitutional? And there is a different view that is expressed by scholars in different countries. Of course, in India itself, this particular concept has had a very rich history. And the world over, especially people like Gary Jeffrey Jacobson and people like Michael Rosenfield, they identify how the Indian Supreme Court has contributed greatly in this regard. Of course, historically, we all know what happened, from the time of Shankari Prasad versus Union of India. The concept of whether the amendment could take away this or could take away that had always been a question. But, in Keshavananda Bharati versus Union of India, the Supreme Court reached, hit upon the right way of doing this. We decided to ensure that we will not allow the constitution to change if it takes away the identity of the constitution. We call it, of course, the basic structure doctrine. All of us know what the basic structure doctrine is. What is the basic structure doctrine? The basic structure doctrine, is a device that was, adopted by the Supreme Court of India in Keshavananda Bharati's case to determine the validity of a constitutional amendment, where the Supreme Court says the Parliament can amend any part of the Constitution it wants to. No doubt. Because before that, in Sajjan Singh, in Golaknath, there was a different opinion. But then Keshavananda Bharati reversed it. Keshavananda Bharati, the Supreme Court said, you amend whatever you want to. Because in that particular instant, fundamental rights had been amended, the preamble had been amended. There was a lot of pending litigation challenging these amendments. So the Supreme Court said, no problem, no doubt. The Parliament has the power to amend the Constitution, the power to amend in fact, the provision that gave the Parliament the power to amend also had been amended. To give effect to multiple objectives. Number one, that it becomes power to amend, because in the earlier case in Golaknath, the Supreme Court had said that the provision has the heading procedure for amendment. So power to amend the Constitution doesn't come from Article 368. It comes from legislative power of the Parliament. Therefore, it can be regulated by Article 30. In Keshavananda Bharati, this was reversed. In fact, the government had gone on to amend Article 368 and change the title to Power of the Parliament to amend the Constitution, and thereby 368 became the source of the amending power. And the Supreme Court acknowledged it. So fine. amending power extends to all provisions of the Constitution. However, it shall not extend to the basic structure of the Constitution. You cannot take away from the basic. And what is this basic structure? This basic structure, if you look at it, if you look at the judgment itself, many of the judges, in fact, there were six opinions in which the judges went on to, give lists of their own. They said secularism, independence of judiciary. They said rule of law. They said fundamental rights. There are many different concepts that have been outlined, listed out in subsequent cases as well. Then after Keshwananda Bharti, there was Minerva Mills, there was Indira Gandhi versus Raj Narayan, there was Kyoto Holohan versus Zaki Lu, there was Ayar Coelho versus State of. Many of these cases, many different aspects of the Constitution were called as a part of the basic structure. In fact, this very particular case is taken by one of the scholars who writes on constitutional identity, and he refers extensively to the various different judgments that were written in Keshwananda Bharti versus Union of India in order to identify. Look at these concepts. The Supreme Court is not necessarily saying you cannot, take away a provision that provides for some form of some freedom. You can, no doubt you can, but then, you have to observe whether that freedom was a part of the basic structure of the Constitution. What is this basic structure? It is this basic structure that, we may go on to identify as forming a part of our constitutional identity. But sadly, in Keshavananda Bharti, there wasn't any definition that was given as far as this is concerned, and therefore it remains undefined. What exactly is basic structure? It is a part of our identity, it is a part of our constitutional identity, but we don't know what exactly it is. We have only indicative lists. This may also be independence of judiciary, may also be part of basic structure. The individual liberties may also be part of basic structure. The rule of law may also be part of basic structure, but conceptually only. On a case-to-case basis, we have to examine under the auspices of the Constitution of India. With the reference to context, can we truly call a particular provision a part of basic structure? It is something that is, that has been left undefined by the Supreme Court. But then it's a pretty strong indicator as regards with, recognizing our constitutional identity. In fact, having spoken about this concept in a brief way, my objective has only been to bring about an understanding to the concept, because the concept is a new one. It is being spoken of in many discussions across the globe in terms of this is something that is very new in constitutional law and constitutional theory, and it is something that has found a great recognition by the Supreme Court of India in the form of the basic structure doctrine, which is what I wanted to bring about. But so let me end with something that I want to quote from the judgment in Minerva Mills versus Union of India in 1980. We said this. Remember, our Supreme Court has gone on to say, it says that the Constitution is a precious heritage. Therefore, you cannot destroy its identity. And that kind of brings us to the crux of the issue. We must, strive towards understanding this identity of the Constitution in order to ensure that it is not destroyed. There are many things many people say about it. Yeah, of course, there are positives, there are negatives. And change is certainly a necessity. Without change, the Constitution will not progress, society will not progress. But that change has, to come in a very measured way. The change has to come in a very careful way so as to ensure that our identity is not lost. Because if our identity is lost, then that is the end of our constitutional heritage. With this, I would like to end, this brief session that I've had on constitutional identity. Thank you so much. Thank you, Vikas, for having, provided this opportunity, and thank you for all the people who have given a patient listening so far. And I would definitely be open to taking questions, if any.
Thank you, SREENIDHI, for taking out time from at your place, and that too on a weekend, for sharing your knowledge. And it was beautifully explained, the concept of identity. Thank you, everyone. Stay safe, stay blessed. And tomorrow we have a session on evolution of public interest litigation, the legal journey, and otherwise also how to draft, etc. Do join us tomorrow at 5 p.m. Thank you, everyone. Stay safe, stay blessed.